You may be seated. We are on the record already. The case has been called again. Ladies and gentlemen of the jury, have you elected a foreperson? Okay, who is that person? Okay, and let me ask you, Madam Foreperson, have you reached a verdict? Your verdict was unanimous. Okay, take a look at that. Preview for the judge. At this time, Madam Foreperson, I would ask you to stand and read the verdict form to the defendant.
Okay, one, guilty of assault with intent to do great bodily harm, less than murder or by strangulation. Count two, we find the defendant guilty of domestic violence. Count three, we find the defendant guilty of assault with intent to do great bodily harm, less than murder or by strangulation. Count four, we find the defendant guilty of assault with intent to do great bodily harm, less than murder or strangulation. And count five, we find the defendant guilty of unlawful imprisonment.
Thank you, Madam Foreperson. Take that jury form, the verdict form. Counsel, anything? Okay. I don't, and if the attorneys don't want the jury polled, I'm fine to not do that. But we will set a sentencing date in this matter for
April 12th.
April 12th at 1:30 p.m. And again, thank you for your service.
All rise.
24 and 25, People versus Kevin Lacroix, 21545 FH, 21546 FH.
Just Lynn, and people.
Good afternoon, Your Honor. Senator Information on behalf of the Lacroix on Zoom screen.
All right, Mr. Lacroix, can you hear us? Yes. Okay. Today's the date and time set for a few things. Just give me a second.
Your Honor, perhaps Blanche and I should approach real quick.
Sure, if you want.
I filed 5 motions. One of them was to fire Sam. Put in the private box. Expire, and I'm not violating my rights further.
All right, so let me let the record reflect a little unusualness in this case. Mr. Lacroix has filed a series of motions on his own behalf, and these motions are appellate motions that have to do with discharging an attorney, remanding for a Ginther hearing, disqualifying the judge, requesting or filing a motion for a judgment notwithstanding the verdict or for a new trial, and then supplying records and transcripts. These are all motions that were filed directly by Mr. Lacroix. Mr. Lacroix is represented by Mr. Bernstein, and so what I will not do, Mr. Lacroix, is I will not hear motions filed by parties where they have lawyers present. So Mr. Bernstein.
My attorney.
So Mr. Lacroix, I'm going to finish and then I'm happy to hear from you. But what is not going to happen is you're not filing your own motions while you have a lawyer. So if you speak with Mr. Bernstein and he files a motion to withdraw, I'd consider that. I'm not saying I would grant it, but you should know that all the motions that you filed are on appellate issues that you're not waiving if we proceed to sentence in this matter. So I don't know I'm not going to do anything today because based on Mr. Bernstein's representation at the bench, he hasn't had a chance to go over the pre-sentence report with you, and that's one of the critical elements of this. He said he dropped it off to the jail. He's not sure if you had an opportunity to go over it. So what we will do is we're going to adjourn your sentencing 2 weeks, and if in that time you've gone over it with Mr. Bernstein and you're satisfied to proceed, we can do that via Zoom. But if that's something that doesn't happen, then I'm going to have you come down here in person and we're going to proceed to sentence in the matter. Okay? So that's kind of the next step. I'm just letting you know that. I am going to take the victim's impact statement today because she's here. I'm not going to inconvenience her anymore. But I will do that. But let me ask you, is there anything you need to tell me before I invite her to speak?
Yeah, Michigan Rules of Professional Conduct 1.16 state that I'm allowed to discharge my attorney at any time for any reason. And the very first motion that you see on those papers is a motion to discharge my attorney. Therefore, any other motion after that, I'm filing pro se because I don't have an attorney and he doesn't need to file a withdrawal if I've already discharged him.
Okay, but it's not as simple as that, Mr. Lacroix. I mean, I appreciate that you have done your research, but and you do have rights. There's no question about that. But that, as you know, as we've gone through this, this is not your first rodeo in firing a lawyer, and you know that there are certain safeguards the court has to put in place to make sure that you have standby counsel or you have other people that are prepared to advise you. Because what happens is this sometimes muddies the record, where you're then later claiming that you didn't understand what was going on because you didn't have a lawyer. And so part of my consideration in your motion might be to require that you hire a lawyer, or might be to require a hearing on whether we're able to proceed today. So I'm just letting you know that that's kind of where we are with that. This isn't going to go on forever, and we'll take it up as it comes, and there's no problem doing that. But what I'm going to do is adjourn your sentencing to April 19th at 1:30 p.m. That's 2 weeks from today.
26.
I'm sorry, April 26th. I misspoke. April 26th, not April 19th. And so what is going to happen in that time period is you're either going to talk to Mr. Bernstein or you're not, and I'm going to take this up on the 26th, and we're going to go ahead.
So
One way or the other.
You recuse yourself?
No. Why would I do that, Mr. Lacroix? Why in the world would I recuse myself after a jury trial? There would be no reason to do that.
Well, if you would read the motion that I sent to you regarding it, then you would know why.
Okay, well, I have read them, but thank you for that pointer.
I'd like the chief judge to take it up then, please, or the state court administrator.
Okay, well, in order for the chief judge to take it up, I would have to act on that motion, and I'm not doing that. So,
Okay, so the Judicial Tenure Commission will act on it then.
sir, if you'd like to make whatever record you'd like to, I've given you ample opportunity throughout these pretrial proceedings. At this time, though, I'm going to ask our court recorder to mute you, and I'm going to ask the victim to come forward to make a statement.
Thank you. Me,
Your Honor, he
Please.
just left.
There's nothing we can do about that. I am here, Ms. Stong, to hear from you, so please feel free to tell me whatever you need to tell me.
First of all, this is called a victim's impact statement, but I don't think of myself as a victim. I think of myself as a survivor. And,
I'm going to sit forward with that and pay attention because I like that.
the assault on me impacted my entire life in so many ways. The connection with my children, my home, my work, my faith. All were changed so drastically as a result of this event. I was ashamed of the way I looked. I had bruises all over my body, my arms, eyes, legs, wrists, scrapes on my neck, face, hands, elbows, knees, feet, my right side. I had a bald spot on the left side, top of my head, with a laceration big enough for 6 stitches. I couldn't get comfortable to sleep. My sight was scary with the floaters in my vision. It hurt to swallow, smile, and cry. I was unable to work, therefore unable to make money to pay bills. Friends took me in to heal and get back on my feet. I quit my job because I moved out of the area and ended up with an eviction, even though I was in communication with the landlord. It took 6 weeks to feel well enough to job hunt. There was a delay because my head laceration got infected. It had to be reopened, the stitches taken out, expressed, and closed with staples. A couple of months after I finally started working, my index finger still wasn't healed up. Turns out my finger was infected. There was dormant infection eating away at the bone. That took 3 incisions, multiple stitches, and 3 weeks to heal. Enough to go back to work, causing my full-time status to go to on-call. Got another financial setback. It took a couple of months before I could get back to full-time status. During that time, Mr. LaCroix kept calling me multiple times each day. Every time it happened, I relived the assault. It was like he was invading my life each time, no matter where I was, what I was doing, it happened. I still couldn't get away from him. I gave him 3 years of my life, love, and resources. It made it difficult to let go of my feelings with that daily reminder. I was scared to leave him. Mr. LaCroix made a promise to kill myself and my children if I ever called the police. When I would try to leave, he would use force to make me stay. He would also break things that were important to me, like my hearing aids, glasses, and my phone. To this day, I don't know where my children live, nor do I have any contact with them. They have done this so they can feel safe from Mr. LaCroix and his promise. I have long-lasting effects from this assault as well, besides losing the relationship with my children. I saw a chiropractor for a work-related injury. It was discovered that I had arthritis on my spine. When I went to get new glasses, a cataract was growing in my right eye, both are a result from trauma. I have a dent in my head that's never going to go away. Multiple scars on my hands, knees, and midway down my right side. The mental healing has been a slow uphill climb. Stumbling over roots along the way, but always getting back up and keeping on, keeping on. I still panic from hearing loud noises and sudden movements. And when the floaters in my eyes were more pronounced, it was scary. I kept seeing things, thinking someone or something was coming at me. It's a terrible way to be. As far as my opinion on Mr. LaCroix's sentencing, he needs counseling for his PTSD and rehab for his drinking. And prison time, because there needs to be consequences for his actions. I would like to see the maximum time available for sentencing. Hopefully, it will be long enough for him to rethink his life choices, to make a plan so he can be the kind of man his mom would be proud of. I've learned a lot from my relationship with Mr. LaCroix. 2 important things are, I'm not responsible for other people's choices, including their mood, actions, and reactions. The other is, I don't have to accept abuse, verbal, emotional, nor physical, as a part of a relationship. I'm better than that, and I deserve better. I'm not the same person I was when I was Kevin's baby doll. I'm more cautious and less trusting on who I give my love to. I feel like I'm ready to live again. This event has held me captive long enough. Thank the court person.
Can I ask you a question?
Yes.
You called yourself a survivor, right? I would agree with that. I would agree with that. I'm very grateful for you coming in here and sharing that with me. I know it hasn't been an easy road for you. I've sat through all of this with you in the trial, and all of those hopeful words that you've told me that you're coming through this or coming out of this. I congratulate you on your grit, on your strength, on your own abilities, and I thank you for coming and sharing.
Thank you.
Okay. So you don't need to, if you want to come back in 2 weeks, you can. You don't have to. I've heard your statement, and you're not going to be.
I'm not sure if I can. I've already put the work on.
It's up to you. But again, know that I've heard you, and you don't need to. Okay?
Thanks.
Okay. Okay, we'll be back on the 26th at 1:30.
Numbers 18 and 19, People versus Kevin LaCroix, 21545 FH, 21546 FH.
Jessica Blanche, appearing on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein, here on behalf of Mr. LaCroix. I don't think we have him. Then I'll probably ask to approach, Your Honor, at the appropriate time.
Client wish to discharge him as an attorney. There have been a number of motions, I'm going to say filed. I mean, they were originally, I think, filed by Mr. Lacroix, and then I think Mr. Bernstein noted them all for the court today, or last week or today. Procedurally, also, we were here on the 12th of April for sentencing. We began discussing the motion. I believe the defendant either left the room or refused to participate. So what we did was we stopped I didn't rule on the motions at that time, but we did take the victim impact statement. So the victim was here. She made her statement on the record. The record should reflect she is here today as well. So if she wishes to make any additional statement, she is invited to do so, but not required to do so. But we are going to proceed today on the matters that are before the court. So I am happy to hear from you, Mr. Bernstein, as it relates to any of the motions. I have reviewed them all in some detail. And if Ms. Blanche wishes to respond on the record, she may do so. Again, I've reviewed the motion, so I'm ready to go on what's been filed. So go ahead, sir.
Just to note that in the court informed Mr. LaCroix that I told the court that Mr. LaCroix continues to wish me to be discharged, and that's reflected in his motion. But I have no further argument on his motion, but I want to note that I did relay that to the court.
Okay. On any of the motions?
I have nothing to add on the motions, Your Honor.
All right. Ms. Blanche, do you have any response at this time? Or do you want?
I don't, Your Honor. The defendant was not in her at the time he submitted the motion to the court. He did have an attorney at the time, which he should have submitted them or submitted a motion on his behalf, which he didn't. So I would ask you to not appoint him new counsel. I said before he could represent himself in pro per would stand by Mr. Bernstein, but at this point we're ready to proceed with sentencing.
Okay. I'm going to take them one at a time. As to the motion to disqualify this court, a motion to disqualify the judge must be filed within 14 days after the party led grounds for disqualification. The moving party must also file an affidavit. Basis for disqualification, essentially that the court issued adverse ruling, jury instructions, and a question, and that the court did not instruct the jury on unanimity. A couple of things I will place on the record. First, regarding the jury note. It looks like on February 27th, 2023, a note was presented to the court from the jury as it related to the count of unlawful imprisonment. The response to the note was that criminal jury instruction 19.8 of the jury instructions had been read and was to be reviewed by the jury. Knowing, let me just state for the record, jury instruction 19.8, the definition, the defendant knowingly restrain another person, quote, restrain, end quote, means to forcibly confine the person so as to interfere with that person's liberty without that person's consent or without lawful authority. The restraint does not have to exist for any particular length of time and may be related to or incidental to the commission of other criminal acts. That jury instruction literally defines what restrain means. That was an instruction read to the jury. That was an instruction that was reviewed by the jury after the question. That was a part of the decision for the jury to make as it relates to evidence, or that is not grounds for disqualification. As it relates to the question of unanimity, criminal jury instruction 3.11 was also read to the jury. Sub 3 says a verdict in a criminal case must be unanimous. In order to return a verdict, it is necessary that each of you agree on that verdict. In the jury room, you will discuss the case among yourselves, but ultimately each of you will have to make up your own mind. Any verdict must represent the individual considered judgment of each juror. So that was read to the jury. That is the jury instruction as it relates to unanimity. And so the court will note that it instructed the jury on both matters as it relates to both the question and then the objection from the defendant. The other note dealt with a clear question of fact, and because of those responses to the jury, the defendant's motion to disqualify this court is denied. As to the motion to discharge trial counsel, that motion is denied. There is no basis to discharge counsel for a Ginther hearing. As to the claim for a new trial, defendant fails to clearly identify and brief what are his grounds for a new trial or judgment notwithstanding. All the defendant does is cite the court. The court is not going to rule on a motion where the defendant just announces his position, leaves it to the court to discover and rationalize claims, nor is it acceptable to only give cursory treatment with little or no citation of supporting authority. As to pursuing post-judgment, appellate counsel will be makes that request, and that motion and the motion regarding the new trial or the judgment notwithstanding the verdict would be the very subject of the appeal that is available to the defendant. So there's no prejudice to the defendant by not. The motion to disqualify the judge is denied. The motion to discharge trial counsel is denied. The motion for a new trial or judgment notwithstanding the verdict or a Ginther hearing is denied. Appellate counsel will be appointed so that the last portion of the defendant's motion really moot at this point. I will note for the record, though, that because we are post-judgment now, Mr. Lacroix, remember that you did receive the appeal information, and you do need to make the request for counsel within writing if you want court-appointed counsel within writing.
Never received it.
Well, mine has been to visit you several times, and I attempted to give it to you.
I can drop it off today, Your Honor. So
One
there's no
more reason why I'm moving to discharge my attorney is because I've never received the appellate counsel forms that you say that I should have received with him coming up here.
Judge. He hasn't
Get them today, sir.
he hasn't been sentenced yet, so technically.
Sentence today. This is the day you get them, so not to worry. Okay, but I am going to proceed to sentence on this matter.
I move for immediate review of the motion to disqualify by the Chief Judge of the Circuit Court, Your Honor.
Okay, well, you don't have that option today, but I am going to move to sentence you today. This is the date and time set for sentencing on this matter. Mr. Bernstein has identified that he has been to the jail with your report. He has delivered it to you, and he is not sure whether you reviewed it. So we are going to proceed to sentence at this time. I am going to ask some questions. Mr. Bernstein can answer most of those, but I don't know if you reviewed it or not. Okay, so what I'm going to ask, if you will recall the last time this happened, if Mr. Lacroix does not wish to participate voluntarily, he may be removed to his cell, and I would ask that you set up a computer monitor outside of his cell. We'll move this down the docket a little bit, and once he's ready to go, we'll recall the case and I'll proceed to sentence. Okay?
I'm going to beat on the door the whole time.
If you want to participate, Mr. Lacroix, we can. If you want to do it from your cell, we can do it that way.
I'm going to do this from now on to you, Judge, for being the way that you're acting, the way that you are being improper. We're all going to do this from now on. We're all doing it. I'm telling you, Gibbs, next Wednesday when D gets sentenced, he's planning on beating on the door. We're all doing it to this judge because he's doing shit like this. He won't hear us properly. He is not allowed, when I make a motion for the Chief Judge of the Circuit to hear it, he's not allowed to say no.
Okay, well, pause for a moment. We'll let you know when we're ready, okay? I'll be right back. I'm not leaving because I'm pissed off or anything. I'm just leaving. I have a question.
All right.
Back up. For Mr. Donald.
Thank you, Judge. Torshio Feaster, Assistant Public Defender, on behalf of Mr. Charles Donald, who is appearing via Zoom. Mr. Donald, please state your name for the record.
Charles Donald.
So, Mr. Donald, I know we're trying to accommodate you, but I can't see your face.
I've spoken to him, Judge. He wants to come in person.
Okay.
We can set this out to maybe May 17th. He'll take the time off of work.
Okay.
He'll come in person,
Section, Mr. Emmons?
I don't have any objection.
All right, so we'll go ahead and adjourn this May 17th.
Yes.
At 1:30 PM, and it'd be good to see you here, sir, and we'll get it all taken care of, okay?
Yes, sir.
All right, see you then.
Thank you, Judge.
Yeah, thank you.
Oh, do you want to do that now?
If the jail is ready, then you don't, looks like they are.
Yep.
Take a $12 ticket. Just as long as he pays the same day. Let's see SAG strips. Give that a try.
Oh,
Calling numbers 18 and 19, People versus Kevin Lacroix, 21-1546. Yesterday, people.
Bernstein for Mr. LaCroix, Your Honor.
okay. Today's times. I am just going to place on the record that during the prior hearing, Mr. LaCroix was present. He did object to proceed. This time I've directed staff at the jail to return him to his cell and to place a computer device that Mr. LaCroix can hear and see. If he chooses to outside of his cell, I'm noting for the record that the Washtenaw County Jail moniker at the bottom left identifies Kevin LaCroix as that cell. I can see a person in the cell, although there is covering over the window. My assumption is that is the defendant, and so at this time we are ready to proceed. So I am going to proceed to sentence. There is a pre-sentence report that has been prepared. I had an opportunity to review the pre-sentence report. I have looked at the guidelines prepared by the correction. I'm going to do an argument on those guidelines for both defense counsel as well as prosecutor. I've gone through reports myself. So all of that kind of comes together when I issue a sentence in the matter. So let me start though, Mr. Bernstein. Other than the date change originally scheduled for April 12th of 2023, so that would be updated to the 26th of April 2023. Are there any additions, corrections, or deletions to the information?
One thing I don't love about the report, Your Honor, is the extensive listing of traffic civil infractions in our history section. I don't think we really need that for these cases, and it just sort of clogs up the PSI, and it's confusing. Like disobeyed traffic signal, no proof of insurance, and it's not really. I don't think it's appropriate to include. It's not relevant.
Well, I mean, that may be part of a work group that you joined, Mr. Bernstein, as far as the revamping of the record. I don't really look at those things. Take that into consideration, how I would proceed, but I remain or the relevant felonies, and then if there are relevant misdemeanors. And so Mr. LaCroix has 12 felonies and 25 misdemeanors. Some of those misdemeanors are comprised certainly of those traffic offenses, but that's not something that really goes into impact.
Just the civil infractions. I mean, I understand there could be non-scorable traffic misdemeanors that are normally listed, but like when I was looking at this, there were just so many civil infractions. I thought, well, that's not.
Because he's not maybe a good driver or a conscientious driver, that does not impact my decision. While I appreciate it does make for a thicker report, I'm not considering those in any part of my sentencing. So thank you for that. I'm not going to do it, but I'm ready. I will note also for the record technicality, although when I say the informational part of the report, it does go to count 5 in the pre-sentence interview report that served current to the. So I've also asked probation to update the report to make that change so it goes to the judge file correctly. I've also requested that the probation department reissue sentencing information reports to reflect my name rather than Judge O'Brien's name on it. So they're all good to go for today. I've made the corrections, but we'll proceed. So let me just ask Ms. Blanche, do you have any additions, corrections, or deletions to the information, not the guidelines, but the information?
No, Your Honor.
All right, let's talk guidelines. Mr. Bernstein, are you comfortable with the guidelines prepared by MPOC?
I have the guidelines, Your Honor. I understand the prosecution right, and I may have some responses that they appropriate to.
Let me hear from you.
Judge, I'd ask to open for 10 points. Victim was touched by any other type of weapon. There's a case, People versus Lang, 251 Mishat 247, 2002 case, where the victim was struck in the head with a glass mug. In this case, we actually had testimony where the victim was struck in the head with a steel-toed boot. So I'd argue that it'd be the same. So we're asking 10 points to be scored.
Okay.
Both the unlawful imprisonment score and also the assault with great bodily harm intent to do less than murder.
Okay, and Mr. Bernstein, response?
I do dispute the scoring of OV1, Your Honor. We're talking about a kick that occurred while someone was wearing footwear. It's not something that was grabbed and utilized as a weapon separately from something. There is no case law that says that footwear would constitute a weapon. I have all the SATO guidelines. It would list if there was a case that involved footwear being an assault. And my concern is that anytime that someone kicks another person, that would be raised to the level of a felonious assault if they're wearing something on their feet. I think it's distinguishable from this glass mug case because this person must have picked up a glass mug to use as a weapon, whereas in this case, there was just footwear being worn. So I would ask that OV1 not be scored, Your Honor.
Any particular or specific response to Mr. Bernstein, Ms. Blanche?
No, Your Honor. I believe that it should be scored.
Okay. I think that I will say it's a novel argument. I've not heard that before. I'm not unpersuaded by that, but I'm not going to make the change to OV1 at this time. I am cognizant of Mr. Bernstein's response. I do think that there is potentially a difference between the intent of the defendant where it just happened to be wearing a certain kind of article of clothing versus the of picking up something as a potential instrument of injury. So I'm going to decline the argument time, and I'm going to move ahead towards sentencing. So I
have more. Sorry.
Go ahead.
OB4 too. Sorry, I'm asking for OB4 to be scored at 10 points. The victim, she actually made it. She also as I said, she was speaking of a steel-toed boot among other assaults. She stated on the record that she was afraid and thought it was going to kill her. She stated that the exact statement that the incident continues to affect her and she wishes she could receive mental health services for the trauma she went through. I believe that is OB4 should be scored in that case.
All right, Mr. Bernstein.
And Your Honor, I'd ask that the score remain the way it's scored in the PSI.
I do agree with you, Ms. Blanche, on that the victim's statement, moreover, her testimony, so do you have more, right?
I have one more. Sorry, Judge.
Go ahead.
OB10 should be scored at 10 points. There was a domestic relationship was involved. She testified that on the stand that they were domestic partners and that they had a relationship, so that should be scored at 10 points.
I kind of wondered that too. Bernstein, do you that?
Yes, Your Honor, I would dispute that. The mere existence of one or more factors described in MCL 777.40 subsection 1 does not automatically equate with victim vulnerability. And just because there's a domestic relationship does not automatically relate to that, Your Honor. So I'd ask that it remain scored as 0 as in the PSI.
Any response?
No, I mean, that's actually, it actually says in there, or domestic relationship. Under the defender exploited victim's physical disability, mental disability, or youth or ageness or domestic relationship. It says it specifically within the OB guidelines.
Well, in Your Honor, it says, it's defined as to exploit a victim is to manipulate a victim for selfish or unethical purposes. So it's not just a domestic relationship. It has to be the exploiter of that, Your Honor. So I'd ask that it not be scored.
agree with Ms. Blanche and her analysis at this point, so I am gonna, reform, or I'm going to store OV 10 at 10. Anything, I'm not bringing these up to you, which is why I keep asking you, do you have anything else before we go to the?
No, that's it, Judge.
That would raise the OV to 70. That's gonna raise the OV level to what?
You say 58 to 114. You don't score the OV one.
So OV though goes up to 70, OV level stays at 5.
OV level, yeah, it does not change. I had to change with the OV1 score, but if you don't score OV1, then it's nothing.
All right. And then how does that change? I didn't calculate.
It doesn't, Judge. It stays 58 to 114. Just the OV level is to 70.
I have
It's still within-
38 to 70.
Okay.
Oh, I'm
Your Honors.
Sorry.
Sorry. I'm on the wrong form. Excuse me. 58 to 114. Yep. Gotcha. So. All right, very well. I do find that there is adequate information in the pre-sentence report based on that, as well as the argument by the prosecutor to have made the changes to the guidelines as it relates to the 58 to 114 is not changed, but all right. So we've had a victim impact statement, Ms. Blanche. Does the victim wish to make another statement, or?
She doesn't, Judge, but I would like to address the court on this.
Okay, I'm happy to have you do that.
Thank you, Judge. The defendant has 12 prior felonies, 25 prior misdemeanors, most of which involves hurting other individuals. He was on parole when he committed this offense. He's taken no accountability for his actions. He's been disrespectful to this court. In fact, he walked off screen when the victim was making your impact statement 2 weeks ago. The statement will be part of the defendant's MVOC. I encourage him to read it when he gets to MVOC. I'm asking you to sentence the defendant 9 to 15 years based on his prior conduct, based on the way he acted towards this court, based on his taking zero accountability for his actions, and his criminal history. In fact, he was on parole. Thank you.
Okay. Mr. Bernstein, do you wish to comment on any other sentence to MDOC, so there aren't any conditions, but allocution on behalf of your client?
Yes, Your Honor, and it's difficult standing here after trial loss. It's difficult without client participating. I hear, I can say, and I know it's been an inflammatory situation. Mr. LaCroix has done good in his life. He served the Navy honorably. He served with the military. He did obtain rank there. He was engaged with what he did for our country. And following that, he continued his service by working with defense contractors and going all over the world to be in different countries and serving the purposes of our country. It was, a work and job that left him injured for life, scarred for life. He did that in the service of our country. And, in doing that, he has demons, Your Honor, and they have caught up with him, and they resurface from, every once in a while. And he started getting in trouble after leaving this work behind. And, here we are today, Your Honor, but he has done good in his life. Unfortunately, he has demons under the surface that are getting him in trouble. And, sincerely hope that he's able to conquer those one day, and move forward. I would ask the court to take note that he has sat in the jail on what is dead time for a very large amount of time, about, I don't have the days in front of me, but I think it might be about 2 years at this point, Your Honor, that he didn't get credit for on this case. And he has a significant MDOC sentence in front of him with parole afterwards, and it's still consecutive to the current sentence that he has. I would ask the court to please adopt the recommendation.
Okay. I do approach for 1 second. I just want to make sure I get, and I need probation too. All right. Record. Over, I wanted to make sure. Second case, 21-545, that is not being dealt with today, and I just wanted to make sure that that was correct from the pre-sentence report, and it is. So we are sentencing Mr. Lacroix on 21-546. He was found guilty by the jury on counts 1 through 5, and that is what we are proceeding with today. Mr. Lacroix, is there anything you wish to say before I impose sentence today? Okay. As to count 1, assault with intent to do great bodily harm less than murder or by strangulation, there are guideline sentencing recommendations of 38 to 76 months. It is the sentence of the court that you serve 5 to 10-year term of incarceration with the Michigan Department of Corrections, concurrent to count 2, 3, 4, and 5, and consecutive to your parole. Number 1, you must not have verbal, written, electronic, or physical contact with Amanda Strong, either directly or through another person, and you must not be within 500 feet of their residence, school, or place of employment. Number 2, you must pay a $68 state cost as ordered by the court. Number 3, you must pay a crime victim assessment in the amount of $130 as ordered by the court. And number 4, you must pay court costs of $1,611 as ordered by the court. Count 2, domestic violence and or knowingly assaulting a pregnant individual, third offense. There are no guideline sentencing recommendations. It is a sentence of the court that you serve 3 to 5-year term of incarceration in the Michigan Department of Corrections, concurrent to count 1, 3, 4, and 5, and consecutive to parole case. Because it is the same case, I will strike the state cost on that matter. Count 3, assault with intent to do great bodily harm less than murder or by strangulation. There are no guideline sentencing recommendations. It is the sentence of the court that you serve 5 to 10-year term of incarceration with the Michigan Department of Corrections, concurrent to count 1, 2, 4, and 5, and consecutive. Number 4, assault with intent to do great bodily harm less than murder or by strangulation. There are no guideline sentencing recommendations. It is a sentence of the court that you serve 5 to 10 years term of incarceration with the Michigan Department of Corrections, concurrent to counts 1, 2, 3, and 5, and consecutive to your parole case. And I will strike number 1, the condition that you pay the state cost in that case. As to count 5, unlawful imprisonment, the guideline sentencing recommendations are 58 to 114 months. It is a sentence of the court that you serve 9 to 15 years of term of incarceration with the Michigan Department of Corrections, concurrent to count 1, 2, 3, and 4, and consecutive to the parole case. So that's actually, it just needs to say consecutive, not concurrent.
Correct.
Okay. I will strike the condition that you pay the $68 state cost as ordered by that court. You have now been sentenced, Mr. Lacroix. Mr. Bernstein will drop off an appellate rights form. That form contains important information if you wish to file an appeal. Most important time frame that's dictated by that is that if you wish court-appointed counsel, you must make that request within 42 days of today's date, and that request needs to be in writing, and that information is on the form. So you will be able to access that once Mr. Bernstein drops that off to you.
And Judge, the accompanying case was an aggravated stalking case that happened around the same time that this case happened. The people moved to dismiss that at this point.
Okay, any objection to that, Mr. Lacroix?
You said Lacroix, no.
I'm sorry, any objection to that, Mr. Bernstein? My bad.
I don't have any objection here.
Okay, so I will find that order on submission. Case number 21-545 is hereby dismissed.